Hello, I'm June Casey from the Harvard Law School Library, and I'd like to welcome you to the Harvard Law School Library Faculty Book Talk series and to our book talk for Professor Lewis Sargentich and for his recently published book titled Liberal Legality, A Unified Theory of Our Law, published by Cambridge University Press. The book can be ordered online through the publisher and is also freely available to you through the Hollis Library Catalog. Before we get started, just a few housekeeping items. We will be recording this talk and we'll post a link to the recording on the library's website next week. Please check out our Scholarship at Law blog for more information. We also thank Dean Manning for his support of these talks, and I would also like to offer a big thank you to our library team, including Rachel Parker and Maya Bergamasco, for helping me to put together this series. We welcome your questions and invite you to use the Q&A feature throughout the talk. Time is reserved at the end of the presentation for our author and commentators to engage with your questions. My colleague Maya Bergamasco will be monitoring the Q&A and will share your questions later. Okay, finally, it is my pleasure to introduce today's panel of speakers, including the author of today's book talk, Lewis Sargentich, who is a professor of law at Harvard Law School and has been teaching courses in torts as well as jurisprudence and legal theory since 1973. He is joined by our local commentators, Duncan Kennedy, the Carter Professor of General Jurisprudence at Harvard Law School. Professor Kennedy is a founding member of the Critical Legal Studies movement. And finally, Professor Charles Freed, who is the Beneficial Professor of Law at Harvard Law School. He was formerly the Solicitor General of the United States and Associate Justice of the Supreme Judicial Court of Massachusetts. My apologies for the sake of time. These are incredibly brief introductions for our distinguished speakers. Thank you. And without further ado, I turn the microphone over to you, Professor Sargentich.
Okay, thank you very much, June. I hit my stopwatch to try to be brief. Hello, everybody. I have to say I'm going to have a shot at describing themes of my book in a short compass. And I've kind of thrown back here in memory a long way to when I was on the debate team in high school and early in college. And I actually was able to work with time frames like 10 minutes for a presentation. But since then, I've had this job where teaching law where the premium is on kind of being valuable. And so I'm going to try to be brief and put the idea, or the thrust anyway, of my book in a nutshell. And so so I thought to start by saying that this book called Liberal Legality is based on, kind of draws upon two ideas that are pretty familiar, not my own exactly. And then it goes from there. The first idea is an idea of the legal realists in American legal culture in the 1930s, this iconoclastic crowd that's been so important in American legal thought. And basically it's the idea that we ought to ask the question, what's law like? What is law? We ought to ask, well, what is law as argument? How does law appear as argument? How does it work? So to figure out what law is, what its nature is, and so on, we should look at law in motion as reasons leading to judgments. I think of that as a realist insight, and it's certainly part of this book. So with that insight in mind, we imagine doing law within a practice of argument. And at the center of that practice are these judges who make arguments about the law, reason from the law to judgments, to results, resolutions of cases, controversies. And then we picture these lawyers and litigants making arguments to the judges that are fit for the judges to embrace, arguments about the law, what the meaning of the law is. And then we picture everybody else and anybody else in social life making an argument about the law. I'm permitted, you're against the law, you're breaking it, making arguments fit to be presented to the judges because they're fit to be adopted by the judges. That's a practice of argument. And so the realists lead us to ask, if you want to know what law is, what its nature is, ask how such a practice works. Now, a practice of legal argument has certain criteria defining what's good and sufficient argument. And the second idea I want to borrow, although I develop it in the book in a particular way, is an idea that's all around us. And it's the idea of the rule of law. So what does the argument, legal argument in our legal practice try to do? What's it work to do? What's it committed to? Answer: to bring about the rule of law in legal judgment and in the operation of law. So the book says, well, the rule of law, you can unpack that three ideas: entitlement, justice, and rationality. Legal entitlement, legal justice, and legal rationality. So it says you have the rule of law in society when legal entitlements exist. That's when valued positions of people in social life are knowable just according to the meaning of the standing laws. Then entitlement under law exists. And legal justice exists when you have a practice of decision under the law whereby like cases are decided alike within the meaning of the general laws. These are familiar ideas: government under law, legal justice, evenhandedness. And the third one is the idea of rationality. The rule of law exists when there is rational resolution under the law. The rational constraint of the law gets you to a result. And that happens, it's dependent upon, it happens when the laws are coherent, when they fit together and they don't collide with one another, they work together. So, okay, we grab the idea of law as argument, and the idea of a practice of argument, we grab the idea of the rule of law as the aspiration of this practice, and what do we have? We have liberal legality. That's the name of the book. Liberal because the kind of law that does honor entitlement and secure justice and realize rationality in law is the kind of law prized by a political position that prizes, that seeks equal liberty. So that's the reason for the name, liberal legality. Okay, so now this sort of the stage is set. And then the book asks the question, well, what happens then in this practice? What arises or develops in the practice? What's legal argument actually look like as it goes forward? And the answer given in these pages of my book called Liberal Legality is, well, what happens is a threefold quest takes place. Two kinds of law are developed. Two kinds of legal pursuits arise within practice. Two kinds of law go forward. One is called formal law, law of rules. The other called idealized law, which is law based on and developed in line with principles, policies, and purposes, ideal aims of the law. So the claim of the book is that those two pursuits, dual impulse, arises in our law or within liberal law, and that's a general truth. Excuse me. And two pursuits plus a generalized quest to make the laws cohere, to make the laws fit together and work together. And that idea of the quest of coherence is an overall idea. It operates within formalized law. It operates within idealized law. That's the claim about the threefold quest. Okay, now the book gives a general description initially of law as rules, laws hammered out by rules. I'll mention three theorists in my presentation now, but they're all pretty well known. H.L.A. Hart, contemporary 20th century legal theorist, British, has a portrait of law as rules And it's a display of law worked out as rule-like propositions that operate without any sort of moral inquiry to figure out how the rule works. Now, Hart is a sophisticated formalist. He believes formal here means just not ideal, not moral. Formal rules work for the most part in their cores. They control cases. They have gray edges and penumbras, and there some ideals are brought to bear. But the main thing, what makes law law, what makes law work, is the rules. So that's a picture of formal law. And then, but for my picture of idealized law in the book and today, I refer to Ronald Dworkin and his portrait of laws, principles, policies, and purposes. Okay, so anyway, that's the setting for the book as a whole. In the book, I identify two authors who not only point to formal law and idealized law, but also to show how these two forms get coherent, build structures. And the first one's maybe a little surprising. It's Max Weber, the great sociologist of law, who has a portrait of formal law, building structures, building coherence, a terrific portrait, I believe, of the impulse to coherence building and seeking in formal law. And the other one is Ronald Dworkin, who's terrific about the idea of coherence operating in ideal argument within law. Okay, so far the thing is a cheery analysis. Mine, it's the ecumenical, come one, come all, formalists, idealists. But there's a cutting edge to the book, the analysis of the book. And the cutting edge basically goes like this: that a good picture of law our law has in mind a specific argumentative practice in quest of coherence. A bad picture of our law is one that ignores coherence seeking and portrays law as falling apart without the push to coherence. So we have some bad pictures, actually, in just the people I've mentioned. And I want to kind of indicate what I think is bad. And it's a critique, but not a good one, of our law. Here they are. So Max Weber says basically this: formal law works. It builds coherence. And he has a terrific portrait of that. Using my terms, but idealized law, what he calls substantive rationality, idealized law doesn't work. It can't sustain the rule of law. It's a pure kind of moral commitment that doesn't fit things together and establish entitlements and justice under law. And my argument is it's just a bad portrait of the way ideal principle policy argument works in our law. It's coherence seeking. Maybe it doesn't succeed in rational resolution. That's a critique, of course, that's possible. But the good critique would be, sure, ideal law shoots for coherence. The trouble is there's coherence and counter-coherence possible. Weber's picture doesn't say that, and it's a bad and pretty much inadmissible, I think, portrait of ideal law. And I think the same thing is true of Dworkin. Strong as his views are, important as he is as a legal theorist, and strong they are, important he is. When he looks at formal law, it's really crude. It's a portrait of single rules and all or nothing application when formal law works. And all of the structuring of law is on the ideal side. Not true, obviously not true. Anybody, a student of law who looks at the restatements of American law, which are formal documents, sees formalized doctrine, i.e. That fits together, that structure. Now, once again, I'm not saying there's no critique here possible, but that's a bad critique that doesn't pay attention to the specific push always present within liberal law, our law, to coherence seeking. A critique that says, okay, for every coherence, there's a counter-coherence. That's a good critique. I'm not getting into that in the book, but I'm suggesting that ignoring coherence is a caricature. And anyway, that's the cutting edge that I can offer in less than 15 minutes, according to my stopwatch here. So I'm gonna cease and desist at this point. Our project is for Charles to speak next and Duncan later. I want to just say, Charles, before we start, so when I was in law school, Charles was my teacher in a legal theory course. When I then went on to clerk at the Supreme Court, Duncan was there clerking as well. So three of us go way back, and it's a pleasure to be on the same screen with my colleagues. So, Charles?
Thank you, Lou. How do we do this so that anyway, it doesn't matter. Am I filling your screen? I'm not filling mine. Lewis.
Oh, well, no, you're a nice picture, very clear. Your background's clear.
Good, excellent. This is a wonderful book. In rather short compass, it makes an excellent case for a view of law, which I completely agree with. I get off the boat only in the last few pages, and only because I think Lou doesn't go far enough. Well, let me just say what struck me. In a case in 1607, Chief Justice Coke issued a prohibition against a decision which the king had made in a dispute. Actually, it was about professional licensure, which he had made with the assistance of his counsel. And Cook said, no, this is a matter for the common law, a prohibition on that. And he stopped it. The king was offended. And he said that he thought the law was founded upon reason, and that he and others had reason, as well as the judges, to which it was answered by me that true it was that God had endowed his majesty with excellent science and great endowments of nature, stable genius. But his majesty was not learned in the laws of his realm of England, and causes which concern the life or inheritance or goods or fortunes of his subject are not to be decided by natural reason, but here we go, this is what we do at the law school, by the artificial reason and judgment of law, which law is an act which requires long study, 3 years, and experience before that a man can attain to cognizance of it. That is what Lou is putting before us. He's putting before us a system of the artificial reason of the law. But he justifies it. And I think, well, morally justifies it by saying this system, which must be comprehensive and coherent, and I like the emphasis on coherence, is necessary for liberty to exist. And that is, of course, his lodestar. This is a system of liberty. And in this, he follows a teacher who was a teacher, though never formally of mine, John Rawls, who has as his lodestar that the first, he actually says that justice is the first virtue of institutions, just as truth is the first virtue of systems of thought. And I think actually that's where Lew soft pedals things a little bit at the very end. Well, Rawls said that a primary feature of justice is liberty and equal liberty. And you can only have equal liberty under a system of rules of law, and of course, a comprehensive and coherent one. So that seems to me to be a very fine lodestar indeed. Now, this system of rules and standards and concepts requires stability of thought, a certain stability of concepts built on stable meanings of words, on the possibility of communication. And Lew makes his case, I don't need to make it for him, where I differ gently from Lew is when he gives an account of something he calls modernity. Actually, one might say that Lord Coke was an example of modernity. I think we've had modernity for quite a long time, even in ancient times. Lew seems to suggest that you need law and you need the stability and the comprehensiveness which law gives, because all around is a sea of turbulence, of unstable meanings of words, unstable concepts, concepts that can be flipped and made to contradict each other by just changing a word and so on and so forth. You're familiar with the trope and the practice. And law is a kind of stable island within that, because if it were not, there would be no liberty. There would be chaos, and chaos, of course, ends up meaning the rule of violence and the stronger. Well, I don't think there is the discontinuity between law and concepts and words, which Lew says law provides an island of repose in the middle of. Sorry, dropped the ended that with a preposition. I don't think it's like that. I think law is continuous, that if you do not have a certain stability of words, a certain stability of concepts, you could not have law at all. And in fact, I'd go deeper. What I like to think of is the biblical story of the Tower of Babel. And you know, God visited a punishment on those who sought to build a tower up to heaven. And the punishment was to make them talk in separate languages. Well, think about that. And I suppose really, it's not, there were English speakers and Chinese speakers and so on. Everybody spoke a different language from everybody else. That, of course, is a vision of thought and communication, which leads to chaos, as God intended to in the story of the Tower of Babel. You could not build anything. You can't cook a meal. You can't have a family. You can't have a conversation. You can't have poetry absent some stability of meaning and stability of concepts. And law is simply a continuation of that and depends on it as so many other things do. Now, one of the interesting things is that law is argument. Laws do change. It is not static, it is stable. Those are two different notions. And the stability comes from the fact that change comes through argument, and change in law, as change in every other dimension of human thought, comes from striving to even greater stability, even greater comprehensiveness. And you're never there completely. Of course not. But the question is, what are you looking for? Scientists, which is an extreme example, of course, science does not imagine that it has arrived at any final truth which can never be overturned. However, it attains conviction for those things which it has persuaded itself of, and it believes that it can happen, even though you move further. My last image is the image of, at the end of the second part of Goethe's Faust, which is the image of constant reclaiming of land from the chaos of the sea. And that is a never-ending struggle. Well, so it is with law, but so it is with all human thought. Thank you.
Thank you, Charles. Quite wonderful. I guess I'll say something at the end, but we got to hear from Duncan first.
So I'm very delighted to have been invited to participate in this book presentation. The book is fascinating. I would say it's a fascinating book, which I approach as an outsider. The book actually deals with Roberto Unger and myself. Roberto is refuted, and I am cast aside as simply not liberal legality with my jamboree of critical moves. And I accept that position in relationship to it. I have, I would say, a very, very outsider view of the internal point of view. So I see Lou as an extreme expositor of an internal view of law. And in my 12 minutes, I want to spend 4 of them saying something about the book as a classical or conventional work of jurisprudence in the Anglo-American mainstream tradition, which is defined by many of the authors in his bibliography, though many of them are not there, which is, Rawls and Dworkin, but could be in England. There would be people like Neil McCormick and Finnis. And then if you go back to the 19th century, there would be people like Holland's jurisprudence and then Austin's jurisprudence. It combines them with some German classics, which is unusual. So Weber figures, though Kelsen does not. Rudolf von Jhering doesn't, although he's probably more important than Dworkin in the development of what you're calling idealized argument. So I understand him as working in that tradition. And then the question would be how to characterize his contribution. There he does contribute to some classical debates in the sense of endlessly new and interesting forever debates. And the main one that he's intervening in that sense is the debate between Hart and Dworkin. And in the Hart-Dworkin debate, he's basically saying they're both wrong because each fails to adequately include the other. So it's a very classical move in theory. It's the middle child's move, but the middle child who is asserting his patriarchal authority after making the move. So the middle child move is mommy and daddy are both right. Each of them underestimates what the other says. So, and that was part of Lew's summary, which was crisp and clear. So they're both right. That's a kind of an intervention in the debate where I think, just to put it quickly, the difficulty occurs with the formulation later on. They're both right, but more than that, he's asserting the relationship between them within liberal legality as a project can be ideal rather than parallel and separate. The boys with their toys in parallel play, they can be seen together, which would be when the rule-based approach falls short, the law runs out, it's replaced by the ideal approach. And when the ideal approach becomes too chaotic, it can be rescued by being formalized, by being reduced to rules as necessary. So that picture, again, is, yes, one can imagine that. In order to understand where it fits all together in the book, I want to go to a second aspect. So my next little segment here is not about how the book is, in a sense, a very conventional intervention in this mainstream jurisprudential debate. And Charles can engage it on many levels because it has all the aspects that are present in the debate, the theory of institutions, a theory of discourse, and a theory of argument specifically. And I disagree with maybe a quarter, but only a quarter, looking at myself, and I think it's got many interesting insights. Great. But that's not, I don't think, why you, my audience, our audience, should read it. I think you should read it because it is a truly innovative, in a very general way, intervention in the debate, and one which is so interesting that it deserves to be taken up not for its conventional jurisprudence position, but quite the contrary, for the ways in which it is really different from that most of the elements in that tradition. And that is because liberal legality is personalized, organicized. Now Charles actually has in his thoughts some organicist elements, he always has had, but that represents a tiny sub-theme of the general jurisprudence literature, and in general, heavily anthropomorphizing, personalizing, even embodying liberal legality as the enterprise of our law. So there's a we, and the we have a law, and inside the law, that which is law-like in our law is when the we pursues collectively. So liberal legality pursues things. It aspires to things. It longs for things. It is deeply committed to things. It operates in a way which is more explicit in this work, I think, than in any other mainstream jurisprudential work. One of the reasons why Charles likes it is he has some little organicist hints in much of his own work in which this embodiment occurs. Let me emphasize the embodiment idea. So the law as doctrine out there is a body which is perfectly plausibly sinful, defective, and so forth. There's a brain, a rational brain, and there's a heart. The law, understood in this personified way, has a heart, which is its commitments, its ideals, its longings, and its aspirations. So if you want to read something different from Hart or Dworkin or Weber, who is explicitly hates all things like what Lewis done here. So Weber's methodological career was debated to methodological individualism, rejecting the idea of the coherence of ideas like Lew's, but Weber is also the sociologist who Lew uses completely appropriately. That's good. But Austin loathes this kind of thinking. Who likes it? Well, the real predecessor in this respect for Lew is let's just start with James Coolidge Carter, who was a professor at Harvard Law School. Charles held the Carter Professorship. I hold it in abeyance. Martha Minow holds it now as non-abeyance. Carter was a Savignan. And this part of Lou's work has Savigny, although he's never mentioned, I have no idea whether he's any interest, whatever, but Savigny was incredibly similar to Lou. He's like that in the sense that Savigny is an organicist formalist. He's both an organicist. His idea of the zeitgeist is that we, the German people, have a common normative project, a set of ideals, and they are actually possible to be rationalized and stated formally as liberty. Liberty is the basic ethos, and it's Kantian. So Kant is the hero of the zeitgeist at its formalized level, but in practice, it's all chaotic. It's all over the place. The role of professors is to purify and formalize it. It's a liberal ideal. It's anti-democratic. And democracy, I must say, figures in Lou's book as one single paragraph in the whole book. A very surprising, really surprising, but that's the way it goes. So the Savignian idea is that you can have both the idea that there's the people, there's us, there's our law, which is a thing. It can be then reduced to a rational kernel, which can then animate, inform, ramify, and now to the second part of the discussion, the single most interesting emotion of law. So really, you're never going to find another classical jurisprudence book that has the story in these personalized form where you can ask about what law's emotions are. So I just mentioned law's upbeat emotions, and Lou seriously understates in his presentation of the book that he just gave you the most striking emotion of law, which is fear, anxiety and fear, read out of the conventional jurisprudence account. And that is the last 25% of the book. A quarter of the book is about not anything that Charles is talking about at all. It's about law's fear. So this is the first formally and elaborately organicist formal jurisprudence book in the normal mode of jurisprudence, parallel with hard work and blah, blah. But it's also the first book, I believe, of jurisprudence ever to seriously address the fears, and the fears could be summarized as the tradition that is brought together in critical legal studies. So the last 20% of the book says, what about critical legal studies? Oh my God, law needs to be scared out of its wits because the tradition represented by critical legal studies is constantly saying to law, understood as us, the our, Lou's collective our being, you can't do it, you're wrong. The goal of coherence, the goal of even openness, all the basic goals of rationality are unachievable. And that's a fear. Now, here's what's really new about the book. He basically says, given everything that's gone before, that could be true. It could completely be true in two different ways. But here's where I agree completely with half of what he says, and I think he just doesn't deal with the other half. Half of what he says, it could be true, but if you look at crit works other than my own, Duncan Kennedy's works, you can find a long list of the people in the tradition from Marx, even including now Weber, but also Roberto and Peter Gable and Claire Dalton and Jerry Frug. All these people have assertions of why it can't work and they're all wrong. And I completely agree with that, as I've said multiple times. I think all of my fellow crits' attempts to do a silver bullet of global internal critique that destroys the project are wrong. And I've said that over and over again. Then he says, now, and so I agree with that. And like him, I am a modest skeptic both of rules and of values. So I think rule argument sometimes works and sometimes it doesn't. And I think moral or purposive ethical styles of argument sometimes work and sometimes they don't. So there, Lou and I belong to a common actual generational skepticism about a particular, which comes from behind, from the 50s, about a particular generational new left ambition to have the silver bullet. I don't share it, never have shared it. So then how do we differ? So his position is it might be true, even with modest skepticism, of course, if we looked at our law under his approach and we see judges who are often making claims to legal closure where legal closure is impossible, either formal legal closure through rules or normative through the way they present policy argument. So policy argument is part of law, but it can be really bad if it falsely does claims that balance produces a clear answer when it doesn't. So those things are possible, definitely possible. Within the domain of modest skepticism, it's possible that the critical approach might argue that as a matter of the practice of our law in the United States right here today, it is the case that claims to coherence are a pipe dream. They're something some people strive for incredibly hard. The distance between the reality and that aspiration is so great that we need something else, which is analytics to explain what happens. Other than, now this is my last point, in Lew and Charles, if you don't have their version of the rule of law, you have chaos, you have dictatorship, you have individual power. That's absurd. We people who think the rule of law functions part of the time, sometimes it doesn't function. We have a whole sociology to understand what is bringing about the results. And arbitrariness is the last thing to think of. Rather, what we've got is theories of how, say, ideology or economics or climate or geography influence outcomes, and what happens when the Supreme Court decides things or when people are nominated. To describe it as individual is absurd. So we need social theory to account for the actual state of law, given that the idealized picture that Lew and Charles present is really so totally, people are struggling for it, but they're just not making it. So we need to try to figure out what's really going on. I really enjoyed the book.
Great. That's quite wonderful news. And so thank you, colleagues and friends. And so I guess it's back to me now for, we're under instruction here to be brief and stay on the ball and so on. So I have not to exceed 10 minutes to reply, and then we'll have a chat function and perhaps some questions from the group that's participating in our webinar. And so let me, I guess I'll go in order and make some comments on some things that Charles said and Charles Fried said, and some comments on what things that Duncan Kennedy has said. And I don't know that they'll exactly line up, but here goes. First thing, Charles, when you read the quote from Cook out, I love it. It's in the book, The Artificial Reason of the Law. And in a way that expression is a sort of a signature of what I'm arguing, that essentially, of course, we people engage in discussion and use common language to make ourselves understood. And of course, we people engage in moral argument and moral judgment just as humans. And law does both. It uses general conceptions of language and thought, as in linguistic exchange. And it has practical moral ideas, principles and policies and purposes. It attributes to the law. So there's law's language and law's morality. And the claim of the book is that it's not that, I'm not a moral skeptic. I'm certainly not claiming that there's no such thing as moral truth or right and wrong. So I'm not claiming that morality outside law is unstable and groundless and whatnot. And I'm certainly not a believer that we're actually stuck in Babel in our linguistic exchanges with one another. Can't understand social life or our own lives if you think that. But I am claiming that the language and morality of law is fashioned by an artificial reason, fashioned within a practice, and a practice I try to define rather carefully. It's an interpersonal interaction, people that occupy these roles. Roles are constituted by rules, judge, litigant, lawyer, and so on. And the practice has criteria for what's a good argument, a good sufficient statement of what law's meaning. So it's like a practice, any intellectual practice, a practice of science can be described the same way. And that's the artificial reason of the law, especially when you add the aspiration to have a particular ideal conception. The ideal conception of the rule of law is your aim. And needless to say, there are lots of examples of legal practice over the centuries, and not all of them had the liberal aspiration by any stretch. So the artificial reason of the law is a concept I like, and but I try to define it rather precisely. I guess I just have two other points on Charles's very interesting reflections. Second one has to do with John Rawls, and Charles Fried described nicely the use I do make of Rawls in the theory of justice. I do point out in the book, however, an interesting fact about this very important political theorist, that Rawls actually had two views of law, and one in the theory of justice and one in his later book, Political Liberalism, which is a wonderful book as well. And hey, they happen to correspond to formal law. That's what he's talking about in theory of justice. And in the Political Liberalism, idealized law, where it more or less incorporates Dworkin by reference. So it's kind of interesting that liberal law, liberty-serving law, can be, well, this is my claim, realized these two different ways. Rawls acknowledges it without kind of noticing that he's doing so. Now, the third thing has to do with disorder outside law. And of course, I agree with Charles Fried's assertion that in general communication outside law or outside any specific practice of assumption and prescription, like that between scientists or that between actually just people in a profession that are doing something or trade. Law and general communication, the medium of exchange of all of us when we're not occupying particular roles. Of course, language in that function is able to communicate. But the argument is that the disorders that do occur outside, and the two of them the book emphasizes, the perils, that brings us to Duncan Kennedy's point. Vagueness of language, instability of meanings in the sense that terms of common discourse can be used in a variety of ways, and disagreement in morality. Those are both recognized by liberal law as things that happen outside law and law struggles against. Okay, so anyway, that was that. With Duncan, I want to, well, maybe my time, trying to be scrupulous here, is passing. Maybe I'll just pick up on the word, oh, actually, I want to say a word about Carter, the theorist Carter. I own very few wonderful old first editions, and one of them is Carter's book, which I got out of a catalog. It was up for sale, but it's a wonderful possession, which is in my office, which of course I can't visit. Anyway, so the idea of organicism. I'm a believer in analytical philosophy, and so I've learned an awful lot from Hegel, but my style of trying to do legal philosophy is very different. And so I was trying to, in the book, describe why it is that a practice that comprises as its members all these different judges and lawyers and people in social life who don't agree on lots of things, and they're jostling with one another and they're fighting, why a practice could be said to have an aim, an aspiration, and why it could be said to have a fear, actually more than one fear, And the argument anyway in the book, just to summarize it briefly, is that when a practice of intellectual interaction and prescriptive interaction is governed by certain ground rules, and now the performances that belong to the practice are defined as those that stick to the ground rules, that work through the ground rules to divergent ends, no doubt, but stick to the ground rules, can be said to have an outlook. It can be said to have an outlook. It can, a positive one, an aspiration, a negative one, fear, worry about peril. And so it's in that sense, strictly based on rules that are shared, that this organicist, like there's some larger mind that does this searching and questing and so on, can occur. Anyway, see what you think. I'm very aware. I didn't want to just assert it. I wanted to build it up. I think the building blocks are not wholes. They're not collectives. They're particulars. And anyway, that was my method in being able to say that liberal legality has an aim, an object, a purpose, and it has assumptions that it uses. And so it trends in these different directions. One other thing I do want to comment on is that the book means to set up an inquiry that it doesn't undertake, and it says so in the last 2 pages. And the inquiry is an inquiry into skepticism, legal skepticism, and how you should think about legal skepticism, and the question whether law is doing what it aims to do. And this is a little parochial, but I mean, it's an exchange between Duncan and me. I don't mention form of substance and private law adjudication in this book. And form of substance and private law adjudication seems to be exactly the kind of skepticism that this book invites. Doesn't necessarily endorse it, but it invites it. Why? Skepticism, legal skepticism that speaks of, and this was the attack on Roberto Unger in the book, that speaks of language in general communication, conventional concepts. They have some sort of defect or infirmity, and therefore formal law has an infirmity. That's a bad argument, because formal law's concepts are formed within a coherent seeking practice. And hey, there's a lot of subjectivity and morals outside law, and that's a comment on ideal aims in law. No, it's not, because coherent seeking shapes principles, policies, and purposes in law. But what Duncan says is not that in this article I mentioned. He says, okay, the push to make the law cohere in an ideal vein leads to theory and counter theory, ideal theory and counter theory. That is the kind of critique that is not touched by my prescriptions and signposts and peril warnings in this book. So here's the idea. Conduct the critique of liberal law, fine. But always remember that liberal law is a specific legal discourse conducted within a particular practice where coherent seeking is of the essence. It's just made up to ignore the push to coherence. But if you can show the result is coherence and counter-coherence, ideal theory and counter theory, individualism and altruism, structure and counterstructure, that's another story. That's the kind of inquiry, whether that's true or not, that this book means to sort of, again, Charles, a terrible sentence, clear the way towards, ends with towards. At the very end, I say the book is not going to necessarily conduct various forms of criticism, but it will suggest how they ought to be done, how we ought to go forward. And anyway, that's where the book ends and where I should end. Okay, folks, so thank you very much. I think we have maybe some chat, questions.
So far we do not have any chat questions, but I do encourage our participants to use the Q&A function right now, and I will relay the questions to our panelists.
Well, do you guys have any sir rebuttal?
Oh, okay. So we do have one question from the audience. The question is, Professor Freed's comments on Babel reminded me of the beginning of James Boyd White's When Words Lose Their Meaning, which gets its title from Thucydides' description of the chaos of civil war in his history. How does history figure into your thinking about liberal legality as an organism?
And that's directed to Charles or to me or both?
It doesn't specify.
Well, I'd like to hear Lou on that.
Okay, well,
because I think I sort of addressed it. I'll say a word. History is simply the record of the quest for coherence, which either succeeds sometimes, and the further quest. History is a wonderful thing, but it's the water in which we swim.
yeah, the water in which we swim, so we don't notice in certain ways that that's true. The air that we fly in, it sustains us, but we don't pay attention often. Coherence says, essentially, the push to coherence says, take the legal stuff of your day, the stuff that's there, and show how it fits together the best you can. And so it has a historical subscript today, now, some period of time written in. And since the law can develop, and every time you deposit a new ruling, it does deposit something else that has to be considered or made to cohere some way or another. Coherence doesn't mean everything takes priority. Coherence includes structure. Something has priority, something doesn't. But anyway, the things that are subject to coherence change, of course, in history. And so transformative projects can become possible within law, and using legal argument to shape and guide the stuff that exists. So I guess in the analysis, the history of these ideas wasn't, in my analysis, it wasn't emphasized. But I guess I'm describing a machine kind of law that moves through historical time. And wherever it is on some historical path or byway, whatever you call it, determines how it can operate through coherence at that moment.
Great, thank you. Our next question from the audience. Dear Professor Sargentich, Freed, and Kennedy, it was a pleasure to listen to your book talk. My question to Professor Sargentich is, from a European perspective, it is striking how limited impact Hans Kelsen, who is the most famous legal positivist on the continent, had on American legal thought. And instead of him, Austin, Hart, and Raz are considered to be leading positivists. What could be the reason for that? Is it because Kelsen's theory doesn't really work when it comes to legal argument?
Oh gosh, well now my answer is not. And I don't quite know why. There isn't so much, except for very parochial reasons, discussion of Kelsen in U.S. and in these common law jurisdictions. So Kelsen is Austrian. He grew up as a legalist in a code, civil code tradition. But he came in World War II period, taught University of California at Berkeley for many years. Here's a bad fact about American legal education. He wasn't allowed to teach at Bolt Hall, the law school at Berkeley, because he didn't have an American law degree. He taught in the university there. Well, that's just a bad fact. But Kelsen is, of course, a great theorist. He's had enormous influence in Latin America, as well as other places that referred to. Anyway, so Kelsen is very important. He's rather parallel to Hart, HLA, in that Kelsen, in a nutshell, believes he's a sophisticated formalist. He believes that law is made up of rules, But these rules are open. And so Hart talks about the core and the penumbra. The core formal stuff works well. Penumbra, it's open. And Kelson's got this slogan, it's a terrific slogan. Legal argument is choice within a frame. Now I like frame. I think it's better than Hart. Frame is a structure. And so Kelson has an awful lot to offer. Now, I am talking about a particular part of Kelson's legal philosophy here. Kelson was very much aware of the legal realists and wrote an interesting essay on realism. And, so I'm talking about his ideas of law as argument. Anyway, he fits in this analysis. Duncan,
are we still going? Because if we're continuing beyond one, I would say a word about Kelson.
I think we have the license, right, June? Well, anyway, June Casey said earlier, we do have the license to go over a little because nobody can come into our room and have to rearrange the chairs.
So I would just think—
I'm afraid I've got to quit in a few minutes. So that's because of something else I have to do.
Oh, sure, Charles. Understood.
Me too.
Understood.
So a remark about Kelson would be, Kelson actually figures an amazingly interesting article about Kelson, which is half about Kelson in relationship to American legal thought and his fate in America and all those things. Is David Kennedy's article, which is about Kelson as an international lawyer, where the characterization of him as a rule-oriented positivist turns out to be really inadequate to what he's about. And he looks much more like a liberal legalist in Lew's sense than he does in the usual presentation of Kelson in Europe, based on his initial fantastic short book, which is then rewritten as The Theory of State. And the relationship, and in critical legal studies, the question of whether he's actually, I think, absent because for the reason that you said, but also because the legal realists trashed him so unmercifully.
Mm-hmm.
So he was basically dismissed as a formalist, not in the sense of believing in rules, but as a formalist in the sense of believing in rules as reflecting a structure of a type that the realists denied existed.
Mm-hmm. Hard to understand why that's so. The distinction between cognition and will in Kelson should tip one off that he's not got this idea of something woven into the firmament that you're drawing out, and so there's more of a caricature of formal codes than anything else, I think. But anyway, quite unjust to clearly a great theorist.
Thank you both. So unfortunately, that's all the time that we have for today. So on behalf of the Harvard Law School Library, thank you for the three of you for attending, and thank you also to our lovely audience for attending as well. And enjoy the rest of your day. Thank you again.
Thank you, my friends.
Thank you. Thank you.
How lovely to have this event.